newly inducted and now applicable EU Digital Services Package, which includes the Digital Services Act and the Digital Markets Act. Sumiti, may I request you to get the slide deck started?
You sent the mail to me, Akash.
It's not a big deal.
You can just share your screen, yeah.
I will just share my screen. Just 1 second. Just 1 second.
Yeah, no, your screen is visible, Akash.
Yeah. So thanks everyone for joining it. So this presentation is about some very important development which has happened in the European Union. So the topic of this presentation is the European Union Digital Service Package and its relevance to India. So I am essentially a stopgap arrangement here. This presentation will be led by Akash, who is an associate part of TMT practice. So in this presentation, just to give a context and a background, we will cover Digital Service Acts and Digital Market Act. Now, these are the acts which have been approved by European Parliament and European Council and awaits signature by the presidents of both these institutions, and then they will be published in the official journal, and it's expected that they will be in force by first quarter of 2024. Now, in terms of applicability, both these acts will apply to big tech companies like intermediaries, online platform, e-commerce, search engine, online social networking services, operating system, web browsers, cloud computing services, and other big tech companies providing similar service. Now, the purpose of these act is essentially to create a safe, predictable, and trusted online environment, addressing the issues of illegal content and related societal risk, ensuring protection of fundamental rights like privacy and data protection, and to establish rules to ensure choice to end users and business users. They want to achieve this purpose by creating a framework in which intermediaries, for instance, will be, like in India, will be exempted from liability. They have specified some due diligence obligations on them. They have imposed obligations relating to non-discrimination, transparency, neutrality and impartiality, disclosure, reporting and compliances, accountability, entry barriers, and redressal mechanism. In these two acts, they have also created some regulatory bodies who will implement this act, and there are also obligations relating to disclosure and compliances and imposition of fines and penalty in case of non-compliance. They have also identified a very large online platform and very large search engine based on certain threshold. And these large online platform and large search engines are subject to additional obligations relating to risk assessment, risk mitigation, audit and compliances, which are specified in these acts. So these acts are very comprehensive act, both of them. I think Digital Service Act runs into 312 pages and Digital Market Act runs into 106 pages. So our purpose of this presentation is not to cover each and everything of these acts because they are very comprehensive. What we are focusing essentially is on the obligations which these two acts imposes on big tech companies. And then we will compare, what sort of a regulatory framework exist in India in the similar areas. So we have not covered issues like disclosure, reporting, compliances, penalties, governing mechanism, and redressal mechanism due to paucity of time. We'll probably have it some other time. Now, this presentation, as I said earlier, essentially would be given by uh, Akash, just to be sure that the credit goes where it belongs. This presentation was prepared by him with extensive research on this subject. So I'll just introduce these two slides. Legislative history and backing. I think most of it, which I have already covered with respect to this, except that bullet 3, where is a similar sort of thing is happening in United States. But this United Nations state intelligence activities relates more to data protection, so that the European companies can share data protection with American companies. So that's a sort of a framework which USA had evolved. Next slide, please. So this slide I have already covered in terms of what is the status of these two acts, what is the purpose, and how it will apply. Over to you, Akash, from the next slide. Akash.
Yeah, thank you so much, sir. I think I was muted. Sorry. Thank you so much, sir, for the introduction, and thanks again, sir, for giving me the opportunity. Uh, while sir has introduced the motives and the backgrounds for the European Digital Service Package and established the context and scope within which we will be taking this presentation, let me take this opportunity to take you through the most important pertinent provisions of the Digital Services Act and the key general principles which the Digital Services Act aims to get through. So, Digital Service Act, which in my opinion is the more pertinent of the two, also unfortunately the larger one to read out of the two, is aimed at regulating and proper functioning of the internal market of intermediary services by setting out rules for predictable and trusted online environment while enabling innovation, all the way balancing this act to ensure the preservation of principles of fundamental rights and consumer protection. The three fundamental things that the Digital Services Act sees the intermediaries as must be looked at in terms of the applicability, purpose, and the scope that the Act aims to address. The Act, first of all, sets out the liability of the providers of intermediary services, then specifies the due diligence obligations tailored to the specific categories that it creates. And then it provides the rules on implementation and enforcement of this regulation that it aims to create through cooperation and coordination between competent authorities as well as the intermediaries in question. So this is a collaborative approach that DSA takes. The Act is aimed at regulation of intermediary services and thus largely focuses on the definitions and the explanations of how such services should be categorized. So in that regard, the Act splits the intermediary services into three categories: the mere conduit intermediary services, caching intermediary services.
One second, I think you have to move the slide on.
And hosting intermediary services. So,
Akash, yeah, that's right.
Yes, sir. Yes, I was just going through. So the mere conduit intermediary services, the lightest of the three, is where an intermediary only exists as a mere facilitator or a communications provider, where it does not have any interference with the actual information being transferred. To understand this better, let's think of it as a pipeline from which water flows. The pipeline does not know anything about the nature of the water except that there is water flowing through it. And this is how these the mere conduit intermediaries work. If you have to take a real world example, you can think about them as your average internet service infrastructure provider who have no actual control over the queries being transferred but facilitate the transfer anyway. Moving on to the second category, the caching intermediary service provider. This creation has come across because of the need of efficiency in internet infrastructure. The caching services, if anybody from technology background is here, they would immediately know that the caching service provider is essentially a temporary storage or an automatic storage of information wherein such storage is executed to ensure faster access to this information. Every time you do a Google search, how is it that Google knows exactly which links you have already linked? How is it that the Google loads those websites faster that you have already accessed earlier in the day? It does so by keeping the information regarding these specific websites or the specific things stored in a small offline container right in the browser. So this is something known as a caching intermediary service. And that's how it enables faster access. Lastly, the greatest obligations as well as the greatest regulation is imposed upon the hosting service provider. The hosting service provider provides critical internet infrastructure, and this is basically where it allows you to host and send information over the internet. And these includes things such as websites, cloud service providers, docket providers, online platforms, and more. As we discussed earlier, the liabilities for intermediaries is focused on the nexus and control and the extent of which the nexus and control they have with the actual information being transferred. So for this, you can see since the conduit internet provider doesn't actually know what the information is that is being transferred, they have no liability to it as long as they don't have the information as to the nature of the information as well as the access to alter the information that is being transferred to them. Caching service provider also, depending on the nature and access available to it, are generally exempted from having any liability vis-a-vis the information being transferred. The only exception to this being wherein the caching service provider has had an access to this information because of an employment mechanism and it has not acted in a way so as to remove the information that it has stored without actual knowledge of the fact that the information and the initial transmission has been removed. Lastly, obviously, given the nexus that the hosting service providers have, they have the largest quantum of expectations. The hosting service provider needs to make sure that they do not have an actual knowledge of the illegal activity or of the illegal content and were not aware of the circumstances from which the illegal activity or the illegal content has been made apparent. Also, they were not aware in any case where if there's a case where they're aware of the actual nature of the illegal activity or of the illegal content, they've acted expeditiously or they've acted apparent where they've made sure to disable access or remove that sort of illegal content from the hosting services that they offer. In addition to the obligations mentioned in the last slide, the intermediaries must also adhere to general obligations, a few of which are mentioned here, such as you mentioned access rate to illegal content, and it is upon so it has to be made sure that the monitoring obligation is not to the extent of making sure every single piece of information that is being transferred has been combed through and has been identified and categorized. The obligation is as far as to ensure that the intermediary has acted diligently and in good faith and carried out voluntary investigations to make sure that they've tried to detect, identify, remove, or disable access to the available illegal content of the platform. Additionally, the intermediary must comply by having a designated point of contact to enable the receiver of the service to communicate directly with the intermediary, just like a nodal point of officer. Then the intermediary must comply to have illegal content that that the relevant authority might identify to have such content removed. The DSA goes one step further by trying to make sure that if an intermediary or online platform is aimed at minors or the target audience of the platform is minors, then the conditions and restrictions of use and access must be conveyed to minors in a way that minors can understand. Though slightly broadly worded, this is a unique obligation that the DSA has enforced. And additionally, in case of hosting provider, the hosting provider has to make sure that they have auto reporting systems in place that where any person on the platform can identify and report any illegal content that is available on the platform or that has been accidentally brought onto the platform. Before we move on to the specifics of how an online platform is determined or how the liability of an online platform is determined, it is important to understand the depths of DSA's approach in clarifying the methodology of compliance, which is the most interesting aspect of it. Even before DSA, we've had lots of acts where they've tried to put blanket obligations, but DSA goes into the specifics by trying to understand how the technology works and enable provisions within the technology to create a collaborative solution to the problem. For that, we need to understand the DSA goes into the definition of recommender system. Now, what is a recommender system? The recommender system is basically the automated algorithms and protocol system that any search engine or any online platform would use to prioritize the content that you get. And then once such system has been created using algorithms and protocols, such systems can also be abused. So, as a lot of you might know about the Cambridge Analytica example, where Facebook directed or targeted a certain demography with a certain types of posts to allegedly rig the elections. However, in such cases, this is known as bias, and such biases can be included and put forth in the recommender system itself to target a particular kind of audience or to target a particular demography. This under Article 29 of DSA, this such a recommender system is not allowed, wherein every online platform or every intermediary will have to make sure that they are introducing or providing an option of a recommender system that is not based on the profiling. Now, vis-a-vis the nature and obligations of an online platform, I hand it over to you, Asim sir.
So online platform. So one area Akash has covered is with respect to intermediaries, various kinds of intermediaries and obligations on them. Now, the same act, Digital Service Act, also deals with the online platform. Now, these online platform includes, as the definition on the slide suggests, digital system of interaction which enable interaction between multiple users. That includes online communication search, forum, blogs, social media website, e-commerce website, applications, and more. So things like search engine, online trading system, online advertisement, all could come under online platform. Next slide, please. So these are some obligations. These are not this is not an exhaustive list of obligations. We have just picked some as to what are the obligations of online platform. And these obligations, some of these obligations you can also find in, let's say, the e-commerce rules, which deals with e-commerce entity in India. The first is that it shall not design, organize, or operate their online interface in a way that deceives, manipulates, or otherwise materially distorts the ability of the recipient to make a free and informed decision. Then on advertisement, there is a bar that it should not be based on profiling. Then it shall provide recipient of the service with a functionality to declare whether the content they provide is or contain commercial communication. There is an obligation of a traceability of traders, that if between a buyer and seller, if the transaction is happening, like for instance on Amazon here, then the buyer should have the details of the trader. And that is also a requirement under the e-commerce rules. And the last, it says that it shall design online interface of traders and consumer in a way to enable the traders to comply with the obligations regarding pre-contractual information, compliances, product safety, and information under applicable law. So a lot of things which are the obligations in this act we can find in e-commerce rules, which deals with online trading or e-commerce entity. Next slide, please. It creates a special category called large platform. And these large platforms are very large online platform and very large search engine, where the threshold is linked to the number of average monthly active recipient, and it's 45 million. So if any online platform or search engine crosses this threshold, then they are in the category of very large online platform and very large online search engines. And once they are in that category, they have additional requirement of a due diligence, which is more in terms of identifying systemic risk and then trying to solve it through a design or adopting a mitigation strategy. And there is also a requirement to do an audit and report that compliances to the regulatory authority. This sort of, there is also similarity, let's say, in the intermediary guidelines, which we have, where we make a distinction between significant social media intermediary and just a social media intermediary. And there are additional obligations under Indian intermediary guidelines with respect to significant social intermediaries. Next slide, please. So digital service coordinator is sort of an institution or a body which this act aims to create. Each member state will need to appoint a digital service coordinator as an independent authority, which will be responsible for supervising or implementing this act in the respective state. And so these coordinators are further categorized as digital service coordinator for establishment and digital service coordinator for destination. And Article 46 provides that there will be a European Board of Digital Service where these coordinator would be the member, and they will play an important role in terms of analysis, report, and recommendation. Next slide, please. Okay, so till now what we have discussed essentially is about Digital Service Act, the main obligations, intermediaries, online platforms, search engine. Now, just to make a comparison as to where we are in India with respect to information technology, our IT Act defines intermediary. So that's the bullet one is the definition of intermediary. Now, then Section 79 of IT Act list out conditions that if those conditions are satisfied, then intermediary is exempted from the liability. And these conditions essentially is somewhat similar to, the conduit approach, which Akash had mentioned in his presentation, where an entity is not initiating transmission or selecting a receiver of transmission or modifying any information. It's just an information which is going through a pipe. Typical example would be the telecom operator. Now, in addition to the satisfaction of this requirement, another important thing for an intermediary to avail the benefit of exemption is that they have to comply with due diligence. There are a list of due diligence which are in the intermediary guidelines. Once they comply with those due diligence, they're entitled for that exemption. So essentially, there are two conditions. One, they satisfy the requirement as defined in Section 79, and second, they comply with the due diligence. If both situations are met, then an intermediary is entitled for exemption of liability. Next slide, please. Okay, so this is a intermediary guidelines which came in 2021. Now, this rules deals with essentially three things: intermediaries, online curated content, and digital media. Now, online curated content and digital media, we're not concerned in this presentation because our focus is primarily on intermediary. So this imposes obligations on intermediary, what intermediary needs to do. And this is what somewhat similar to what Akash mentioned in case of Digital Services Act, where there are obligations on intermediary, what they should do in order to get exemption from the liability. So one obligation is that they have to inform the user not to host, display, upload, modify, publish, transmit, store, update, or share any information specified in the rules. And there is a big list in that rules in terms of what information they cannot display or upload. Then intermediary, I mean, theoretically, technically speaking, there is no obligation under this rule on intermediary to search for the content and then decide whether it is legal or illegal and then remove it. The intermediary concept essentially is that intermediary is providing a pipe. What information goes in that pipe? If intermediary satisfies the requirement as mentioned in section 79, intermediary is not responsible for that content, so long as it satisfies the due diligence requirement. However, this rules allows intermediary to remove or disable access to information on a voluntary basis. So on a voluntary basis, they can use certain technique to ascertain whether information is illegal or it doesn't, or it is not, or there is an infringement of IPR. That sort of an information on voluntary basis they can remove. They can also remove if there is a complaint on the basis of a complaint, or if there is a takedown content notice received from the government or the court. The earlier slide, yeah. Grievance redressal mechanism. Now, this was an issue which was sort of a contentious issue. A big online media, social media companies were a bit reluctant to establish a grievance redressal mechanism, especially where there is a requirement that a person should be resident in India. But this is the similar thing exists in Digital Services Act also. Now, there is another category based on certain threshold with this rule specifies, which I mentioned earlier, is a significant social media intermediary where there are additional responsibility, and the grievance redressal mechanism is also more effective in terms of appointing chief compliance officer, nodal contact person, and grievance officer. Then there are obligations that if they are doing advertisement, then they have to inform it to the user that it's being advertised or sponsored. And there is also a requirement to deploy automated tools to proactively identify certain information. Now, this obligations to proactively identify certain information is not on social media intermediary. It's essentially on significant social media intermediary. Next slide, please. Now, to this rule, recently, I think the last month on 28th of October 2022, an amendment was made. It was, I think, the major. We have just captured the major amendment. Although, in addition to this, they have also created an appellate committee that if there is a redressal mechanism, let's say if there is a redressal mechanism at the level of company needs to be challenged, and the government has appointed an appellate committee where a aggrieved party can go and appeal there. But this amendment essentially is important from the point of view of bullet number 1. What bullet number 1 says, that an intermediary shall make reasonable effort to cause the user of its computer resources not to host. Now, in the main 2021 rule, as I mentioned earlier, that there is no obligation on intermediary to actively ascertain whether the content is illegal or not. The main responsibility was to satisfy the requirement of 79 to get exemption, and they are just providing a pipe. But here the term shall make reasonable effort has been used, which essentially means that there is some obligation which by virtue of this amendment has been put on the intermediary to ascertain whether the content is legal or illegal. And then the second bullet point is ensure reasonable access to its service to user with a reasonable expectation of due diligence, privacy, and transparency. So that's essentially a sort of a difference which this amendment has brought to the earlier rule, where the role of an intermediary in a very subtle manner has changed a bit by imposing an obligation of making reasonable effort to ensure that the content is correct. Next slide, please. Over to you, Akash.
Thank you so much, sir, for taking us through the online platforms and the nexus that intermediary and the nexus that it has with the Indian law. Now we'll be moving to the second part of the service package, which is essentially the Digital Markets Act. So Digital Markets Act is slightly different from Digital Service Act. Unlike Digital Services Act, which is aimed at regulating internal market practices, the Digital Markets Act aims at ensuring fair markets, lowering entry barriers, the principles of contestability and fairness. The idea with Digital Markets Act is to create and ensure that even though in this tech age with giant companies taking over and taking control of all our essential services, they're assigning special anti-competitive provisions to ensure that monopoly is not created in such sectors. So the idea is to create a notion of specific services which cannot be illegally taken over, which cannot be taken over by creating absolute dominance and then monopolized over, and then creating another monopoly based on the leveraged position that the company has already created. So it creates a snowball effect, right? So the idea is to to regulate special type of services. So Digital Markets Act takes this approach by identifying core platform services, which it says are provided by designated gatekeepers, which is based on another threshold that we will discuss later in the presentation, and which gatekeepers which provide services to business users as well as end users, which might or might not be located in the European Union. The recipients of the services have to be. So the regulations have been created around the idea of recipients of services and not around the location of the service providers. So this is to ensure maximum and wide implication of where these gatekeepers are trying to create maximum impact. So like I mentioned earlier, there are three large purposes of introduction of the Digital Markets Act, which is to prevent gatekeepers from imposing unfair conditions on businesses and end users, to propose functioning of internal market by laying down harmonized rules for businesses, contestable and fair markets in the digital sector, and providing transparency and accountability framework for online platforms, and provide a single unified structure across the EU. Before we go into the details of how a DMA obligation is created or how a gatekeeper is reprimanded or how the principles of contestability and fairness are enforced and maintained, it is necessary to contextualize the discussion by understanding a few definitions. So what are the services that a gatekeeper has to provide? What are the services that qualify you as a gatekeeper? So a gatekeeper provides core essential services. What are core essential services? The core platform services. The core platform service mean an online mediation service, online search engines, online social network services, video sharing platform services, operating systems, web browsers, virtual assistants, cloud computing services, online advertising services, including advertising exchanges. So essentially all of everything that we see when we go online. From this point onwards, whenever I refer to an end user, in the national sense of any word, end user is a receiver of any service or any product. So that is what we mean. The business user, since core platform services provide so many services and they're so vast in their nature, they also have business users. Business users are people who use the core platform services given by a gatekeeper for commercial and professional capacity, commercial and professional use, and providing goods and services to end users. With these definitions set, we can move on to what the obligations of a gatekeeper are. To understand the obligation of the gatekeeper, we need to refer to recital 5, 6, and 7 of the Digital Markets Act, which categorize as obligations of a gatekeeper susceptible of being further specified under Article 8, and obligations of a gatekeeper or interruptibility of number independent interpersonal communication service, which I think is a deeply convoluted way of trying to draft. So to understand it better, we have recategorized them as obligations that cover aspects such as management of data processing, processing of personal data, processing of sensitive personal information, anti-monopoly provisions, compulsory bundling, advertising services, and publication services. This is the first aspect, wherein the gatekeeper is supposed to be careful with the data and not to discriminate. Secondly, the gatekeeper is also expected to maintain fair and competitive environment by inclusion of obligations by enabling access and choice in the core platform services they provide. These are enshrined in the neutrality provisions as identified in the slide. So going through the slide, we will see that the data protection and data processing obligations ensure that these core platform services, in a situation where the end user or business user is using multiple of these services, is not put in a position where the restrictions on the use of personal service data creates a situation where the personal data collected through one core platform service is combined with the personal data collected through other core platform service. Essentially what Meta is doing with Facebook and WhatsApp. Let's not lie to each other. And Instagram. And they're trying to combine this data to create a complete data profile, which they can use as an advertising profile that they can sell to the advertisers. However, this gives them an unfair advantage because of their position and their acquisition of multiple platforms. Though in the end, this additionally, the portability of data, the gatekeeper shall also provide end users a portability of data generated by them through the activity that the end user has created through the entire use of the core platform service. So essentially, the idea is you can take your entire data and move on to a competitor's core platform service. This will enable fairer competition. The gatekeepers shall also provide business users continuous and real-time access to and the use of aggregated and non-aggregated data, including personal data that is provided for and generated in the context of using the core platform service. Here, the caveat is also given: the personal data must be consented to throughout the provisions of GDPR. Otherwise, the average statistics are provided. Since we're not going into the details, we'll not be going into the methodology on how how the quantum of the data is to be calculated. Moving on to the anti-competitive and anti-monopoly provisions, we'll see that the business users who might actually compete with the core platform services should not be restricted from providing the same products that the online services are providing, but through direct sales channel. This is essentially a seller selling on Amazon for a price and selling cheaper on their own platform. So the gatekeeper cannot create a provision wherein they prohibit the reseller from selling on their own platform, which can be on the same or different conditions. The seller can also allow gatekeeper can also not restrict the seller from promoting and offering these services. Let's say on the Amazon store, they can put out the link to their actual store or the other product website where they're directing shipping the products to the customer. Lastly, non-discrimination. So now the recommended system that we discussed earlier comes into play. Here, the self-promotion or the self-benefit that a core platform service provider or a gatekeeper can use has been restricted, where the gatekeeper is not allowed to rank their services more favorably in context of other services through indexing, crawling, but by any other service provider which provides the same service as a gatekeeper. So they're not allowed to put their search results on the top, and they're also obligated to provide fair, reasonable, and non-discriminatory general conditions for access for both business and end users. So if you recall, so in the last slide when he was discussing the amendments to the intermediary guidelines, which have become as intermediary rules of 2021, there he also discussed the general principle, the reasonable access principles. This is quite similar. So now we are already seeing parallels to the DMA being reflected in the Indian law. So that is why it is critical to understand and contextualize this law. Moving on from the obligations of gatekeeper, these are the specific obligations that have been categorized. There are also some general obligations. These include anti-bundling provisions, where if you want to use a particular service, you have to also use the gatekeeper service to access that service, or you have to sign in through another service. The gatekeeper cannot use bundle payment mechanism. So this is a critical hit for all the Apple Play Store, Apple App Store users, wherein Apple used to charge 30% commission of every purchase and every in-app purchase. So Fortnite, which is owned by Epic Games, sued Apple for creating such a restrictive payment interface. So now you will very soon see third-party payment mechanisms on both Google and Apple stores. It cannot mandate business users or end users to register with any other core platform service, which is in line with the anti-bundling provision I mentioned earlier. They have to maintain fair and competitive environment in the core platform service, which means they can't prioritize and rank their services over any other, or they can't, let's say, create a service where they are creating a premium tier or creating an algorithm through which they are trying to push one particular service to push their own service over any other service provider's service. They have to create transparent recommender systems where they have to show the standards of how they rank their service or show the standards of the algorithms that they use. They have to create fair and reasonable non-discriminatory general conditions of access. This is in addition to the service that we mentioned earlier, to enable proportionate conditions for termination. So in some cases, you will see that core platform service provider would make it impossibly difficult for a business user to exit the service. So the idea here is to allow free mobility. This can be seen wherein your data would not be available to you for transfer, would not download, or would specifically be technically disabled to be used on any other platform. So such conditions cannot be used. Additionally, like I mentioned earlier, the interoperability provisions which are created for number-independent interpersonal communications, which is such a, we can take an example of, let's say, Discord or Instagram calls or Instagram text, or wherein calls and texts are possible without actual use of the phone numbers which are independent, which are linked to a phone number. So such operating tiers should have interoperability. These obligations by no means are exhaustive. However, they give a fair idea of the direction and approach that the Digital Markets Act has taken to ensure maximum competition and principles of contestability and fairness, like I mentioned earlier. With that, I think we can move on to the Indian aspects of how the DMA has a bearing, which will be which will be presented to us by Asim sir, based on consumer protection rules.
Okay. So, I think Akash mentioned about the obligations of the gatekeepers, and we had also talked about some of the obligations under the Digital Service Act, and those obligations essentially relates to neutrality, impartiality, no entry barrier, non-discrimination. A lot of these provisions you will find in consumer protection rules, which deals with e-commerce. There are some provisions which are, I think, in foreign direct investment policy also. But in India, when we are talking of an online platform, the general rules which are applicable to online platform or e-commerce entity are mentioned in the Consumer Protection Act. It is in the form of a Consumer Protection Rules 2020. Now, in addition to that, there are sector-specific online platforms. Like, take for instance, 2 years back, the government came up with telemedicine guidelines. So we can create an online platform which can connect doctors and patients. So there are specific requirements of the platform provider. So while these consumer protection rules are applicable, but in addition to that, there are sector-specific do's and don'ts which have to be adhered to. There is, let's say, if there is a platform on which insurance product is being sold, IRDA has come up with specific regulation with respect to that platform. So when we talk of an online platform, so there are general protection rules. The general rules are in Consumer Protection Act, and then there are sector-specific do's and don'ts with respect to those online platforms. I think there is one in digital lending also, which RBI has issued. So the general consumer protection rules, which are essentially more or less the same, what are given in the what Akash has talked about. One is to appoint a residential nodal person to ensure compliance in grievance officer. Then the e-commerce entity should not adopt any unfair trade practice in the course of business on its platform. It has to disclose the name of the seller so that there is a traceability of the seller when it comes to the buyer. It should record the consent of the consumer. Then not to manipulate the price of goods or services offered in the platform in a manner that it gain unreasonable profit. And it should disclose its relationship with the seller, a description of any differentiated treatment which it may gives to some seller who are in the same category, which essentially is the concept of non-discrimination. Next slide, please. Okay, so that was the last slide. That brings an end to our presentation. Uh, so we are open to questions now. Any question anyone has?
Yes, Advait. I think Advait has a question.
Yeah.
Uh, First off, thank you both so much for diving so deep into this topic so that we could benefit of your hard work. And thank you for putting together a great presentation. I think that the question I basically had was pertaining to in essence, this anti-abuse aspect of the DMA. I wanted to see if you, Akash or Simsa, could elaborate on it a little further. What are the larger policy conversations that surround this?
Adam, so if I may.
Yeah.
So with the DMA, the idea was not to create a full-fledged anti-abuse solution because this would be like putting a band-aid on, let's say, a gunshot wound. Because the idea is not to create rigid infrastructure or rigid framework, which the entire with the
Sorry, Akash, sorry. You could stop sharing now so you can see
yeah.
each other.
Oh, all right, sir.
And by the way, it was a very, very good presentation, and thank you very much. I
Thank you,
learned.
sir.
I think the credit goes to Akash, who has done a lot of research in this.
All guided by you, sir. Thank you so much.
But really, it was very good, and we must have more of these, and we must invite clients to, for example, Asim, just a thought, and sorry to interrupt, Advait, just a thought, we should have had that lady from Amazon, your junior, former, etc. Anyway, please continue.
Right. Advait, so yeah, so we were discussing the larger policy conversations that need to be having. So this reminds me of a discussion when I was researching for the first time on the digital services or Digital Markets Act. So the first time I saw the opinion of Mr. Thomas Kramler, who is the head of the unit of e-commerce and data economy for European Commission's Directorate General of Competition. He discussed the idea of creating a collaborative framework. So the DMA essentially is a setup for that, where the step-by-step process is to invite these big policy gatekeepers for a conversation to make sure that the innovation is also not hindered. The idea is to bridge information asymmetry and invite the gatekeepers for dialogue in an effort to create a collaborative step forward in to create and ensure fairness and contestability. For that, he also discussed contestability and fairness in the light of how it was brought up when this act was being discussed in the draft stage, where the final step would somewhat look like a situation where the companies would rely on gatekeepers to enter into markets or lowering the barriers for entry and using their existing technology. Then they develop their own and slowly create a framework where they find a symbiotic relationship, or let's say a fairer competition where they can find their own niche. And the fairness would be, let's say, a balancing act between the rights and obligations of the gatekeeper and the business users. Because in the end, the idea is to provide the best service to the end customer. I hope that answers your question. And
Just to add one point here. So these acts essentially, let's say, to put it very simply, one of the main objective of these acts is to provide choice to end users and the business users, and to provide it in a manner that there is a free flow rather than creating entry barriers. Now, in addition to that, I think in every jurisdiction, there will be a competition, a specialized agency relating to competition commission. So it's not a replacement of that. There might be some common overlap between these acts relating to, let's say, an abuse of a dominant position or the competition commission. But whatever is the existing framework relating to the competition, that I think exists.
Very rightly said, sir. Because the idea is not to replace the big guns, because they're still present in the DMA. There is a provision for charging percentage of turnover as penalty for non-compliance, and then even restructuring of the company itself as a punishment for systematic non-compliance. The idea is to introduce a collaborative effort. Thank you, sir. Thanks, Advait, for the question.
No, thank you both so much. Very interesting. Thank you so much.
I think Amay also has his hand raised. Yeah, go ahead, Amay. I think you're on mute.
Amay, you're not audible.
Yeah, can't hear you.
Please open your videos, for God's sake. We haven't seen each other for so long. Unless you have some special challenges. Otherwise, what is that light? It comes as if you're in a filter. Yeah, there's something. Anyway, figure that out. Let's have our videos open, please. It'd be nice to see everybody. Thank you.
Yeah, I think Advait is going to write the question.
Let's kind of take the discussion on net neutrality further in terms of that's non-discriminatory practices and all. Does that kind of take this forward, or it kind of is laid to rest?
Can you please repeat your question? I missed one or two sentences.
Yeah, the question is the entire debate on net neutrality. Does this act possibly take it forward, or it's kind of putting it to rest?
So let's say net neutrality in India. So now we have a concept of a net neutrality. There is a definition as to what net neutrality means, which essentially means that everyone will have an access to internet on a non-discriminatory basis. There will not be any preferential, when it comes to an access, there will not be any preferential treatment to any content or application. So this was an issue which was discussed in India 4 or 5 years ago. Now we have a well-defined concept of a net neutrality. And the same concept applies in the European Union also. So net neutrality relates access to internet on a non-discriminatory basis. Now, the non-discrimination, what we are talking with respect to gatekeeper is more so in context of an online platform that, let's say, the sellers who are on that online platform should be treated in a non-discriminatory basis. If there is any special relationship which an online platform has with a seller, then it needs closed, and similar seller should be treated similarly rather than differently. So, so this non-discriminatory is more with respect to an access to the online platform. I hope I have answered.
There is an audio issue.
the question.
We didn't hear you, Asim.
Better now? Is it better now?
Yes.
Yeah, yeah.
No, we can't hear you again.
So, is it better now?
Yes, it is.
Okay, okay. So I'm saying this non-discriminatory, what we have talked about is with respect to non-discriminatory approach, which an online platform has to take vis-a-vis the sellers who are using that platform to sell its product and services. Now, net neutrality relates to a non-discriminatory access to internet.
So doesn't the concept cover?
Can't hear you.
You're not audible.
Yeah, what I'm saying is, am I audible now?
Yeah, yeah, you are.
Yeah.
You are.
My question was whether this digital market act, does it cover the telecom operators also? isn't the definition wide enough?
Abhilek, your question can't hear you. Sorry, you have to repeat again.
Okay. Is it better now?
Yes, it is.
Yeah, so my question is, isn't the ambit of Digital Market Act wide enough to include the telecom operators within their ambit?
So it's so telecom operator are included because they are intermediaries. But
Right.
their inclusion is to the extent they are intermediary, which essentially means that they're providing a pipe. Now, what goes inside the pipe, telecom operators are not responsible so long as they satisfy the condition mentioned in, let's say, which is required for an intermediary. So they are included, but as an intermediary. Now, but there will not be an online platform. Online platform would be like Amazon, for instance, from where the buying and selling is happening. Now, telecom operator will be an intermediary, but not an online platform. So when we talked about non-discriminatory, it was more from the point of view in online platform. Now, as far as the net neutrality is concerned, it's an obligation on telecom operator to give net neutrality, which essentially means an access to internet on a non-discriminatory basis with respect to its content and application. But net neutrality as a concept is not a part of a Digital Service Act or a Digital Market Act.
Okay.
I think Amay has put his question in the chat. Sorry, sir. Sorry, Bhuvnesh, follow up.
Yeah, Akash, what's the question?
Yes, sir. It's with respect to profiling in a recommender system, why is there a need for such hand-holding as envisioned by DSA?
Want to take it?
Yes, sir. So, vis-a-vis recommender systems, I feel that especially EU is a little bit touchy about this topic, given the constant flurry of cases that it has had. So, for instance, we can throw back to the 2014 case against Google, wherein the European Commission for Competition pointed it out that Google was using profiling system and abusing the profiling system by putting the advertisers who were using Google as a publisher to put their ads on top or to put their websites on top. So here in the question of bias and recommender system came into play for the first time. This was reflected again by Meta in 2017 case, wherein German authorities took a look at how the Facebook/Meta group now was taking and abusing customer data by making profiles of customers and advertising those particular customers with specific kinds of ads that they would respond to in a certain way. So these are the two instances. That's why I feel the DSA has taken so much effort to lay down what a recommender system is, put forth the requirement for a impartial recommender system, put forth the understanding of bias. I really don't think this will be a global change, legally speaking, but I feel that this is a good first step and gives out a definition of a recommender system for a legal context. This is technically a technology aspect. I hope that answers your question, Amir.
And I think broadly, let's say on the concept of algorithm, I mean, it's still at a very early stage, but generally, let's say, for instance, this airlines ticketing, if there is more demand or if then the prices goes up. So there was an issue which Competition Commission had taken, and they said, we're not doing anything. It's all algorithm based. But the Competition Commission asked the question that you have built this algorithm, so you are responsible for it. So in a scenario where there artificial intelligence in a scenario will play an important role, where you give an input and there is an output, and there is a machine-driven output. Now that output, in order to test the constitutionality principle, that let's say that output has to be non-discriminatory, it should satisfy the requirement of equality. Now, for that to happen, there has to be an algorithm which are built in a manner that they satisfy the requirement of a non-discrimination and equality. So the time would come, and it's probably happening, I think in US, they have come up with a document relating to artificial intelligence, where they will put a specification or a requirement as to what should go into an algorithm where the decisions are machine-based to ensure that it passes the test of, let's say, fundamental rights in India. Now, if the government takes decision based on the machine, the government decision has to satisfy the requirement of fundamental rights. So algorithm has to be made in a manner that if those decisions are challenged, then the process of making that decision through a machine should be in a position to establish that it doesn't violate the principle of equality.
I agree, sir. Machines are only as good as they're coded as the humans who code them. So, if you have to undertake the principles of, let's say, equality and the principles of impartiality and the principles of fairness, you would have to set a standard for coding them, and you would have to set a global standard. So, the reliance on the machines does not lead to any unnecessary consequences.
I'd like to ask a question. I actually get a view of the house. Today, YouTube uses a lot of bandwidth. Today, TikTok, others, if they're still there, use a lot of bandwidth. Now, I'm a service provider. I've got to get a fixed fee every month from the user. But my bandwidth is taken away by YouTube, which pays me nothing, or by TikTok, etc., etc. Therefore, my service gets slow. Therefore, my customers complain. Therefore, I have to invest more money in making the band, the width, and the tube bigger. Do you think it's fair?
Not at all, sir. However, you think, uh, I think a lot of this consequences are also related to the fact that we are now consuming content at a much, much faster pace, and we are now demanding content of a much, much higher quality. So earlier, let's take the example of YouTube itself. Earlier, we used to get a cap of 480p videos. Now, every other video available on YouTube is 2160p. So an average 480p video would be, let's say, 50 MB for 5 minutes. An average 2160p video is 1 GB for 5 minutes. So the amount of data needed and the amount of bandwidth needed has also grown. But I agree with you in that there is a lot of unnecessary clutter that has also been forced down the pipe. All these advertisements that are being bundled into it, and all these extra platformer services that are being bundled into it in the name of maintaining standards and in the name of maintaining security. So I think it is about time we get some transparency on how these security or standardization protocols are used and implemented.
No, I understand. But see, YouTube uses, like you said, advertisers. They get revenue from them. They get revenue from different sources. But me as a service provider, I'm stuck with my monthly fee.
Yeah, but so that's essential. So there are two things here. One is this debate which is going on right now, and I think it's also a part of that draft Indian telecommunication bill, where the operators are saying same rules for same service. Let's say, to give an example, WhatsApp. You make a call using WhatsApp, but WhatsApp is not paying anything to the operators or to anyone, although the service is the same, making a call from WhatsApp and making a call from Airtel. But it's the same service, different rules. So this operators want same service, same rules. That's one aspect. The second is this concept of, so the argument of the YouTube would be that since there is more bandwidth consumption, operators are getting more. Let's take, if we compare the revenue of the operator today compared to 4 years ago, and if we see the average data consumption now and the average revenue per user relating to data consumption, there will be significant difference. So now the data consumption is very high, and operators are making money from data consumption, not from the voice. But I mean, there are arguments both ways. Yeah.
No, I see your argument. Sorry to just stick with it for a minute more. See, there are some unlimited plans. Now, if I go with the unlimited plan, then who suffers? The service, the guy who provides the service, because he gets a kick because his service is slow. It's not his fault or her fault.
But
YouTube is using all the bandwidth.
so, yeah, you're right. Video, I think they use lots of bandwidth. Uh, uh, but if we see the average revenue per user, it's increasing. What the operator is collecting earlier, I think it was 99. Now it is 130, 135.
I don't know how that math works, but to me, just doesn't feel equitable. And I'm not including on a lighter note all the other videos people on this call see, other than YouTube. Akash knows exactly.
So maybe it is not a factor. Maybe the service providers are not benefiting from the factor of data consumption, but from the factor of data speed. Because now the data speed required to, let's say, push a video through YouTube is also higher because of the higher quality.
But
So,
then sorry to interrupt, but then I have to increase my equipment. I have to invest more money. I have to create more fiber optics. I have to create more bandwidth. And nobody's paying me for it extra.
So I think this
That
was
is
one
my
that
of
makes
the
point.
sense.
arguments. This was
How
one
do
of
you
the
balance
arguments.
this? Sorry, Ablik.
So this was one of the arguments that was put forward by operators when this entire debate on net neutrality was happening. That they should be given some kind of leeway as to which of the sites they can possibly try and give preference to. And this was kind of nipped into the bud because then that was trying to conflict with the rights of the subscribers.
Or one more solution possibly could be, but I guess you're the experts, is that say a YouTube or somebody uses higher bandwidth, they pay a fee.
So this was actually, there was a tariff package like that, what Abhilek mentioned, and what you mentioned, exactly the same tariff package. But TRAI shut down that tariff package on the ground of net neutrality.
Exactly my point. Because net neutrality, see, we have to balance all the players is my thinking. Why should one get killed and the others gain? Like YouTube gains massive. वो advertising में पैसा कमाते हैं, वो उनके the various schemes they have, and yet they don't give a penny to the service provider.
So this sort of package, if you recall, about 5-6 years ago, Facebook has that package called Free Basic, and Facebook had tied up with Arcom, and this Free Basic had internet access to around 100 websites. So if you're an Arcom subscribers, you can access that free. That was struck down on the basis of net, and exactly what you are saying, the differential speed on net neutrality basis.
Anyway, this my view that needs a little more thought, because you're killing companies like AT&T and others. They're going out of business.
Yes,
And the pipe strength is limited. It cannot be unlimited.
That's right, especially with respect to access, because access is through spectrum, and spectrum is limited.
Yeah, that's the problem.
just a
Right.
thought. Yeah, sure, Adit, go ahead.
I mean, I just have a question regarding this. I don't have a solution, of course, but isn't the fact that the pipeline being is limited and no one entity can pay for use of that pipeline, isn't that ensuring a much more competitive environment for that? So yes, big companies may be going out of business, but they can't pay for the privilege of their space, is at least how I'm seeing it. And is that not creating a much healthier competitive environment which will foster innovation and growth of new incomers, or am I mistaken in understanding how this would play out?
No, I would say, I'll let the experts explain, but I would say that it's a very good point, Advait, that this would foster innovation. People would try and bring in fiber optics, different technology. There was a company many years ago set up by Enron,
Mhm.
where that was figuring out how to use the pipes which were empty and direct traffic through that. You see, what happens is that, let's say, the fiber optic in uh, Shantiniketan is much more usage because there are many more computer users there at home. But let's say the same fiber optic also goes to Motibag. That is much less usage. So they can redirect the traffic through that, and all that technology did come up. We worked extensively on that, and then talking of 10, 12 years ago. So innovation, yes. But I'm just looking at it, from the whole story that Akash was talking about in Asim was on fairness and on bringing equality. Here I find a huge amount of, it's not equal at all.
So if we go by, I think Advait has done a lot of research on that, on draft Indian telecommunication bills. Companies like YouTube may fall in the definition of a telecommunication service. And then they may need a license and all obligations relating to licenses.
Mm.
Because there is data streaming. I think Akash is there in the, Advait is there in the definition of telecommunication service.
Yes, but it does feel like that I can't imagine that they intended to bring a company like, or like a service like YouTube within the purview. I think it was I think what they had in mind, it was an unfortunate byproduct of bringing such platforms.
Data service, internet-based service, OTT service. So, I mean, you take your pick.
Yeah,
You can fall in any of this category.
exactly. The buckets are very wide, and
Think of Netflix, think of all these fellows. They pay nothing to the service provider, and they make all the money.
That's what okay. So the model, let's say, of WhatsApp is, so they ride on Airtel's network and compete with Airtel service. So and they don't pay anything actually, license fee and all.
And they pay nothing to Airtel. That's right.
Nothing to Airtel, nothing to government also.
And they ride also on the bandwidth of the government.
Those are great model, but I think it depends how serious the government is with respect to this draft telecommunication bill. If it goes in the form it is right now, all of them will be under subject to license terms and conditions. All of them will have to take license.
And pay for it, hopefully.
That's right. So license means 8% license fee, then a whole lot of other obligations.
8% of what?
8% of adjusted gross revenue.
Sorry?
It's called adjusted gross revenue, and adjusted gross revenue essentially means the entire revenue of the company.
So I pay nothing to WhatsApp.
Yeah. So
what
then
is the revenue model?
So the whole concept will change. For instance, Airtel cannot provide you free service, although Reliance did when it was launched in 2016. But because it will be construed as a predatory pricing, and also if Airtel is giving you free service, it's a loss of revenue to public exchequer. They're not getting 8%.
That's right. Interesting. I'd love to see how we balance it and what the processes are. Maybe that's a thought we could think about. and maybe thought seeded it in the rest of the world.
Any other
Anyway,
question? So, okay then, thank you very much. Thanks a lot. And
Thank you,
in case,
everyone, for
in case
joining
you
in.
have any other question, we can discuss it offline.
thank you. And
Thank you.
also, Sumati, please make a capsule of this and see who all we can send it to. Maybe post it on LinkedIn or something, or Facebook as well. And then Asim, you can think of other people like that lady, Rodi, etc. You could just say this is what we did. So, something like that. Think whether Google or etc. Even send it to Namrita of Metaverse. God bless.
Okay, then.
Thank you very much, all. Be safe.
Thank you.
Thanks a lot. Thanks. Bye-bye. Thanks,
Bye-bye.
everyone.
Bye.
Bye bye, everyone.